Good morning. Uh, you know that certain offences are not permitted to be compromised and seek for quashing the complaint. Those offences are categorized in various cases, like murder, rape, dacoity. All these all are the offences which specifically not permitted, and also 307 attempt to commit murder also was there. But the recently Supreme Court has given several guidelines under which even offences like heinous crimes may be compounded for the following reasons. Here is the case where a case of 307 was registered against several accused, and police has filed final report quashing the complaint because main accused died. And but the lower court did not allow to close the report, and they take cognizance of the offence, and summons were issued after 33 years. So they approached the Honorable High Court to quash the complaint, quash the FIR, quash the charge sheet, claiming that they have settled these issues. But High Court simply rejected the request of the accused, stating that offence is under section 307. So the first concept of this law is settled in this case was AR 2025 Supreme Court 1035. AR 2025 Supreme Court 1035. Naushe Ali and others versus State of Uttar Pradesh and another. First they say the court should not alert for the caption of offence 307. They say they should go through several approaches to permit the compromise of offences. Therefore, they allowed the quash proceedings. They simply say, mere mention of section 307 or penal code in FIR or charge sheet should not be basis for adopting hands-off approach. 307, no quash, no, that was they say. So they have given, they have discussed about various judgments, which was initially a bar to quash the proceedings of grave offences. But they have also discussed about what was quashing the complaint on compromise and compounding. So they have given some directions. That directions is most important. See, my dear friends, you go through this paragraph 20, wherein guidelines were given, and while drafting complaint, while drafting 482 quash proceedings, you have to incorporate all these grounds to convene to your case. So that will be a good drafting. Number one, firstly, these offences, occurrence involved in these appeals can be categorized as purely personal or having overtones of criminal proceedings of private nature. Secondly, nature of injuries incurred do not appear to exhibit their mental depravity or commission of offence such a serious nature that causing of would override public interest. Then it is immaterial the trial against the repellent had been concluded or appeals against the conviction stand dismissed. So even for that you can quash the proceeding. The fourthly, parties on their own volition without any coercion compulsion entered into compromise to put quietus to their dispute. Here thereafter they say pending before or after filing the case, there was no untoward incident happened between the parties. So then they say both the parties are residing within the vicinity of the village or places, and they will advance peace, harmony and fellowship amongst the parties who have decided to forget and forgive all ill will and have vengeance against each other. Then the criminal justice system would remain unaffected on acceptance of amicable settlement between the parties, resulting acute law problem, more so looking their present age. All these things should be considered. So I hope you understand. First, you must think that the court should not simply raise their hands because offences are 307. So this would apply for 302 may not be. But at the same time, 376 and other robbery cases in a private nature, known persons robbery, all these things you can, civil dispute robbery, you can compound the offence by placing this judgment. I hope you understand me. Best wishes.